Welcome to Employment Law This Week. I'm George Whipple. Artificial intelligence is changing the world, and it has already begun to transform our relationship with work. From ChatGPT to tools for hiring and recruitment, the revolution is happening right now. Epstein Becker Green's Alex Franchilli tells us how employers can benefit from AI innovations while remaining in compliance with federal regulations.
As the technology improves over time, both workers and managers will want to rely on artificial intelligence to be more productive and efficient. As we've seen with large language models and what's become known as generative AI, there's now a possibility to streamline many of the tasks that many of us assumed were not possible. But with that, there's also a responsibility for those using the technology to understand its risks and shortcomings. There's currently no federal comprehensive law that directly regulates artificial intelligence. In the meantime, we've seen several federal agencies opine on how pre-existing laws that are on the books now, like Title VII, the FTC Act, and the NLRA, might apply to artificial intelligence and automated systems. We've also seen the White House Office of Science and Technology Policy publish a guidance document titled Blueprint for an AI Bill of Rights, outlining 5 pillars around which subsequent legislation might be structured. To summarize, AI should be safe and effective, there should be no algorithmic discrimination, should respect data privacy, provide adequate notice and explanation, and allow for human intervention and fallback.
The EEOC recently issued a joint statement with the DOJ, CFPB, and FTC officials expressing their concern and intent to continue to monitor developments in AI technology. Epstein Becker Green's J.T. Wilson III tells us more.
There are 3 general areas that the EEOC expressed concern. First, with data and data sets. We know that AI and other algorithms really are only as good as the data that it accesses and the conclusions that it draws. The EEOC is also concerned with a lack of transparency and access. Oftentimes, developers or the end users have a very basic appreciation for how these products actually operate. They just don't know all the nuts and bolts of it, which can increase difficulty of conducting a fairness assessment. And then a third area that the EEOC expressed a concern is with respect to design and use. The universe of potential usage are not always contemplated by the developers.
In diversity, equity, and inclusion, where budgets may be limited, AI could help increase efficiency and maximize value. But as JT notes, sensitive issues like pay equity, parity, and representation will still require human decision-making.
I believe in this space, employers do well to look for opportunities to pair these 2 tools together. DE&I professionals that the employer may have already invested in, and then also leveraging AI to complement the DEI professionals, because it allows them to synthesize and process information in an accelerated fashion, but it still keeps the human element to monitor and to evaluate the viability of the information that's compiled and the recommendations that are made.
Thanks, JT and Alex, and thank you very much for watching. We'll see you next time.